I may move through this a little more quickly than we might hope, but we've got a lot to cover today, and we wanted to try to stick to our schedule. The PowerPoint you're seeing is just a bare skeletal outline of the outline that's in your material. So I ask that you refer to those to the extent that you want some flesh on the bones. We go from Aldo Leopold to John Prine. I learned this song in the front of a canoe on Boulder Lake at Camp Manitowish when I was a kid, only to find later when I, actually went out and bought myself a John Prine album that it's about a town. Paradise, unfortunately, I did not capitalize, and I should have. Pardon me for the editing. As you research into it, though, Paradise was not hauled away by the Peabody Coal Company, but it was a sort of a metaphor for John Prine to describe everything that goes on in the environs of mining. Paradise is in Muhlenberg County. It's a town, everybody worked for the Peabody Coal Company. The most special of whom worked in a big, giant Bucyrus-Erie dragline that was made in South Milwaukee. It's part of our economy. But what happened in Paradise was that they built a fuel plant to burn the tailings from coal, from strip mining, that were lower quality. And they burned that, and it all rained down upon the village of Paradise. And Paradise was actually the first Times Beach, if you remember Times Beach, Missouri. The village had to be essentially bought out by the Tennessee Valley Authority and torn down, wiped off the map. Paradise, Kentucky is gone. A consequence of mining, and that's why it's important in talking about this. While a city like Hibbing, Minnesota has the most beautiful high school you've ever seen because the United States Steel Company built it in exchange for the town letting U.S. Steel move the town, other towns are completely gone. So in representing municipalities, it's very important to try to think about, is mining going to be our friend or our foe for a municipality? And there's a lot of debate about that, obviously. I've been through plenty of late meetings in that regard. Today I'm going to talk about municipal authority, where it comes from, about Wisconsin mining law and other laws that are important in administering your municipal regime as it pertains to mining, and some recommendations for strategies. First of all, a municipality is a division of state government. It doesn't exist out there independently. It's as though it's a subcommittee of the state of Wisconsin, and it's treated that way in statutes. Its basic authority comes from the concept of home rule, which is both in statutes and in the state constitution. The concept of home rule has been variously stated, but for the most part, it is that things that are strictly local are left to the locality to rule itself and not dictated from Madison. The types of municipalities there are counties, of course. There are 72 of those. Those are established by state statute. Cities, villages, and towns. I think we all know generally the differences between them. A city has a larger body and usually is elected in districts to the council. A village is elected at large, doesn't have a mayor. And towns, of course, have smaller boards, 3 to 7 members. And important for towns, they have an annual town meeting that we'll discuss a little bit later, unlike any other municipality. The sources of power are home rule, as I discussed before, police power, which is another concept of those powers that are inherent in being local, and zoning law. Mining ordinances, in particular, can come from zoning authority or from police power. In fact, as we speak, that debate is raging. In the case of, let's see, the name of the case is Zwiefelhofer versus the town of Cooks Valley. In that particular instance, the town did not adopt zoning, but instead adopted an ordinance to regulate sandpit mining. And that was challenged on the grounds that it was actually zoning in disguise and it hadn't satisfied the state zoning statute for enactment. and it has therefore been taken to the Circuit Court and is now on direct certification to the State Supreme Court. It being August, I don't think we're going to hear anything for a while about it, but stay tuned for a result on that. Zoning can be established either as county zoning, which is inherent over the entire state. City, village, or town zoning are also, of course, applicable. Zoning is still the best way to regulate. There's no question about that. A town can adopt, and I'm under the next screen, but a town can adopt zoning by adopting village powers. Once a town adopts village powers, it actually assumes some city powers by virtue of Section 62.23 of the Wisconsin statutes. So with the exception of the city of Milwaukee, which is the only first-class city, it has its own category. All zoning is conducted in exactly the same fashion across the state once a town adopts zoning authority, which that process requires public hearings and approval by the county board, but it is not an insurmountable task. Sometimes a town board is just 3 people, and one of them drives the snowplow, and one of them keeps all the records, and the other one, makes the meetings run long. I mean, that's how most town boards are. But they can still, adopt a zoning ordinance pretty easily. Most town lawyers in town, Rick Stottleman from the Town Association, he'll tell you, they can find a zoning ordinance that's been adopted elsewhere and lead a town through that process. Now, one of the things that that you acquire once you have put together a zoning ordinance is the right under Wisconsin statutes to require a local agreement, specifically with regard to metallic mining. Local agreements are not like a mining permit. A mining permit might be 21 volumes, or at least the application for Crandon was 21 volumes. It's about 50 pages. If somebody writes it the right way and gets to the heart of the matter and imposes very specific requirements in that agreement, and there's a number of things that are required by statute in there, which you see on that list: a legal description, the term of years of the agreement, a list of permitted uses, and a description of terms determined to be necessary for the health, safety, and welfare of the residents. And I'm hitting the wrong button here. There we go. You also need a description of any obligations of the municipality that are necessary to enable the development to proceed. It can't be contract zoning. You can't agree to rezone a property. But the municipality can agree to put in a road or something like that might be required. Very controversial, and it was especially controversial and a big source of the litigation over the town of Nashville Crandon Mine local agreement, is the applicability and non-applicability of municipal ordinances. There are still going to be some ordinances that a mining company is going to ask to be exempt from. The same way your neighbor might ask for a variance or a special exception to build their garage closer to your house or to have a longer pier than they could otherwise have. The mining company asks for those kinds of concessions, and that can bind the town or the municipality, city, forever if written appropriately. Provisions for amendments to the local agreement have to be in there, so there will be reopener clauses, as they're called, and any other terms deemed necessary by the parties. Now, before I jump, and I hit the button too soon again, but let me just give you a list of some ideas as to what some of those other terms might be. In Nashville, we prevented, and this is in no particular order, prevented solution mining, which I think was described earlier this morning. Solution mining is a way of pouring chemicals, acids, for example, into a mine that's already been spent, and then drawing those fluids back out and taking whatever residual minerals are in there out that way. The White Pine mine up in Ontonagon, Michigan comes to mind as the most recent instance of that. That has very little impact on jobs and can still have great impacts on the environment. So in this case, we banned it from future use, and it can be recommended. You can ask for a permit fee, which can be a large amount of money. I mean, it can be hundreds of thousands of dollars. You can require retraining programs for employees. Now, you're looking at 30 years on the back end from development of a mine, but your children or your children's children who've been working in the mine their whole life, they're going to need a job when that mine closes. So it's important to try to put that in advance. Same as we've heard about reclamation of the site. Obviously, the Flambeau site is the sort of thing you'd like to see rather than some of the horror stories we hear globally about lakes and streams contaminated forever. The development of a local impact committee, which is local businesses, local schools, working together with the mining company. Actually, while I don't want to confuse people, so I'll go back to where oh, no, I'm still on funding, huh? Well, regardless. Job preferences are important to put in there, that your people are hired first. You can ask for more money than just that permitting fee. You can ask for payments for takings, for loss of use of surface waters, groundwater, et cetera. You can put a buyout provision in for homes that are impacted and go before a panel and say, look, my lake home is no longer worth what it used to be because my pier is not in deep enough water to get a boat in anymore, and I want you to buy me out. You can require that the mining company agree to that in advance. Specific projects like asking for a fire station. I mean, these things have always been part of the negotiation. Impact fees for schools or development for schools. Tax equalization with neighbors is an interesting municipality versus municipality situation. In the case of the towns of Lincoln and Nashville, they both had a tax equalization agreement with the Crandon Mining Company that said that whichever of the two of them gets the most taxes, the other one gets the same. So you're overtaxing them intentionally. Now, when the other thing that's in Wisconsin state statutes that's important is funding for municipal impacts outside of the agreement. And that comes from the net proceeds tax, which develops the Mining Investment and Local Impact Fund. Years ago, I appeared before the Mining Investment and Local Impact Fund board to ask for money on a discretionary grant, and I saw somebody I haven't seen since then. Jim Buchan is here somewhere, or he was here this morning. He was the chair of it back then. They meet in Madison, dole out what they've got in terms of money to distribute, which is described in the outline. The funds are not limitless, but they certainly are significant. Municipalities get payments from negotiating local agreements. That's to pay for lawyers like me and engineers like we're hearing today, and other experts, even accountants. They receive construction period payments, which are when the construction starts. You get a flat out here's $50,000 or $100,000, depending on how many municipalities are sharing it. The threshold to get that money, in most cases, is 15% of the ore body. So your engineers and other experts become very important. Municipalities are always, if you're close, if you're on the cusp, and you only have, and you think that you've got 17% of the ore body, you're not necessarily equipped to get into a battle of experts with the mining company if they get angry with you and say, you've only got 14%, you're not going to get your money. Because that basically pulls the rug from under you. So you have to finesse these things, be very careful about it, and try to use your experts. First dollar payments are mentioned in the outline. Those come from the first ore that's extracted in the first couple of years. Other sources of funding are damage claims for the withdrawal of surface waters under statute, which is described in the outline. First dollar payments are also made to counties. They go through a different route. Counties have to set aside some of it for the future, and they can only use it for mining impacts. And they can actually make grants to municipalities out of what they've set aside for the future to mitigate further impacts. Discretionary payments to municipalities are what I described before. You might be in the middle of the process, and there simply isn't enough money to continue. The permitting process, with all the hearings and everything else, can take months and years. And a municipality really needs the financial support to keep going without dipping into its own coffers, because the worst of all mining impacts would be to completely disenfranchise a municipality by it having no ability to have any leverage over the mining company. And that leverage comes from having the ability to negotiate. Non-metallic mining is probably the biggest frontier out there that you hear the least about. We're a state of glaciated soils. Half of the state is sand and the other half is gravel when you get south of Highway 29. Because of that, every hill in the Kettle Moraine has got a dollar sign on it to the road builders, and all these patches of sand in the driftless area have a dollar sign on them to the sand fracking people in the oil and gas industry. So Wisconsin has its non-metallic mining law, which really asks the municipality to regulate this stuff. It is optional, but the DNR prefers that a regulatory authority, that being a county, town, city, or village, regulate by its own non-metallic mining ordinance, again, through zoning, although it doesn't have to be, it can be done by police power, regulate non-metallic mining, and in particular, make sure that they engage in the reclamation supervision. That is where DNR comes in. They look at annual reports and they review reclamation plans to make sure that they're satisfied with what's being done on the local level. Now, a couple of things to talk about real quickly, just to mind your P's and Q's as you're going through this process. The open meetings law and open records. In the interest of time, I'll just abbreviate to say that you've got to stick by the P's and Q's of the open meetings law. Certain activities are going to be exempt. That's conferring with counsel, competitive or bargaining reason, and judicial or quasi-judicial procedures. And where it really comes in to play is that competitive or bargaining reasons and conferring with counsel. You can never meet with the mining company in closed session. That's the big fear of public interest groups, and it's what is always suspected to have happened. The only time you ever could is if you have two competing interests, two competing mining companies looking for permits for the same thing, which almost never happens. So you just have to keep that in mind, that you meet with your own counsel, but you really shouldn't be meeting with mining company people in what constitutes an open meeting. So you avoid a quorum, avoid a walking quorum. Send one person to talk to them with counsel, nobody else. Other exemptions apply to employment and licensing and financial, medical, and social personal information, but that would never apply here. Votes should always be conducted in open session. That is not a requirement of law, that's a requirement of common sense, and the AG has said it for years, and I agree with him. If we're supposed to have government under the sunshine, let's have the vote out in the open, especially if there is still there's no longer a reason for the decision to remain private. You have the vote in private if there's a public interest in keeping the fact that there is a decision private. And the public interest means the public, not we on the board. We always have to remind ourselves of that. And it can be frustrating sometimes to public interest groups when I'm telling them that my advice is that it's in the interest of the public interest group, and their members, to keep something confidential for a period of time until it's in the best advantage of the public. And that gets into when you're negotiating something and you want to do what's right for the people. Open records law is similar. Open records include everything. Hard drives on computers, emails, texts, if there are a way to retrieve them, voicemails, everything except perhaps personal notes. They can be time restricted, again, on some of the same concepts, like, for example, the lawyer's advice on how to go about the litigation strategy with a mining company or the negotiations with a mining company. Those can be kept confidential, but only until such time as they're no longer being kept confidential for the sake of the public. It's a concept that you have to keep in mind at all times. And as soon as it's not in the public's best interest, that's when it's over. Enforcement can come from the AG or from individual citizen actions or from the district attorney, and includes minor fines and perhaps the undoing of the work if in fact the action was too tainted by those violations. Property taxation and assessment on the ore body gets to the value of the ore body, the cost of development, and a factor for the likelihood of success. Those tax revenues can be significant. One thing that comes into play, oftentimes, well, two things come into play, and some in this room were involved in this in the Forest County Potawatomi case with the town of Lincoln, I believe it was. Is it the taxability of tribal lands, Federal Reserve lands? Those can be off the tax roll completely by virtue of that status. Another issue is use value, which the Department of Revenue applies to farmland. If there is a farm on top of an ore body, it can be viewed to be taxable as ag land at the going rate for ag land. That's to protect farmers. There is also, once it's developed, a manufacturing and equipment exemption, but that can take out a lot of taxation as well, and this can come into the local agreement where you try to get them to guarantee you taxes on some of this stuff in the agreement. The reveal of the ore body increases its value, and then a depletion factor applies during development. I'll try to wrap up quickly here. The proposed legislation that we might have heard about already today, it's going to be part of the discussion in LRB 2035 for municipalities, would get rid of local impact committees, which are important. I talked about that in local agreements. It would also take away our authority as municipalities over shoreline and wetland zoning and place caps on the net proceeds tax. All of those are, I think, detrimental, obviously, to municipal interests and not in the best interests going forward of my municipal clients. At the same time, Gogebic Mining appears to believe that they need this in order to make their project viable. They are, in fact, holding off on their development until the next legislative session because they'd like to get that through. Now, strategies and recommendations, then I'll wrap up because we're kind of sliding behind on time. Zoning. I need not say more. I mean, you need to have a zoning ordinance, and in that zoning ordinance, you need to have provisions, and this is especially for rural towns, with regard to both non-metallic and metallic mining. You need to require local agreements and planned development districts, conditional use permits for mining exploration and supporting facilities. A mine, when it's built, is like a $500 million construction project in your town, which might have an equalized value of $5 million for the whole town. You need to get a handle on that and regulate it and get your local agreement and your conditional use permit. The same, which I haven't mentioned before, the same is true for exploration. When the mining company comes in and starts, drilling and exploring all over your municipality, it may be too late because, like the Zweiffelhofer case I talked about before, you may find yourself with them, already submitting their application when you haven't gotten your mining up and running yet. I mentioned here, apply for grants at every turn. That money is there for you to apply for. Negotiate for even more money, as I discussed in the local agreement section. Watch your open meetings and open records law requirements, and make sure your residents are getting the jobs. Protect your local environment. The DNR is there to protect you, but it's your house. Double check. Add extra protections. If you're worried about one specific asset that's very important to your community, the lake that is, that's the heart of your town, add extra protections. Prepare for your town annual meeting in advance, because at the town meeting, any group of citizens can come in, pro or con, and direct certain actions by a town, including adopting zoning. That can be a positive or a negative, and it's a matter of who's the most organized and who sneaks up on whom. And I say that because I think democracy is best served when everybody understands that before the event comes up. Educate your assessor. That's about the value of ore bodies, as I discussed before. At least make sure that your assessor attends the right seminars to understand what's going on. And be prepared to yield some future zoning authority. It won't get done unless you are willing to compromise in a few areas. And with that, we're running over a bit, but I thank you. We'll get questions after Paul is done, and I give you Paul on private rights.